Hello, YouTubes. I don't know if I'm saying this early or late or which way, but we are on YouTube. Have you got the notice yet, Matt?
It says meeting is now streaming live on YouTube. Although I don't know if that's true because last time we were on, we talked about Tommy Tube Top a lot and he doesn't seem to like us. So we might have been shut down again.
Oh, you know what? He doesn't talk about us. I never received any email from him. And we sent him an email inviting him here.
Did we send him an email?
Yeah, we did.
I mean,
sent it direct to him, said, "Dear Tommy, we understand you have challenged our channel because of copyright violations, and we wanted to spend some time talking about that on our channel because we think that you're not ripping people off when you talk on YouTube." So
Ray, I don't know about that email, but I think I know what the problem is. And the problem is, why would he come on our little channel? So number one, I think you should resend it, except since you're a lawyer, it shouldn't be a letter. It should be a demand letter. And number two, I think you should demand that we talk to him on his channel. Because that's really what his people
he could have a defense lawyers watching video, and he could get all of the followers that we have.
He could do Tommy Tube Top watching defense lawyers watching Tommy Tank Top's video.
How does he not do that?
It'd be like the Matrix.
Something like that.
It's like taking the red pill or the blue pill. Yes.
So we talked last week, Pat and I did, about, when we weren't doing this, Ray, because you were gone, how much there was to talk about. It was a week ago. I don't even remember at this point.
Did you guys have a show without me? What was it like?
We did not.
You did not?
We did not.
We did not.
Well, I want to, I just want to take a brief moment to show you all what was going on in the meantime. I probably shouldn't. I probably should not do this, but my better judgment is not going to. Let me see if I can find it now. I just had it up. My better judgment is not going to take effect here. Let's see if I can find it back here. Now we're going to get a zoom of a zoom of a zoom of a zoom. I'm gonna. Let me make sure that I get this all put together and back. I'll put it in back. I was going to explain where I was last week.
Ray, the thing I like about you is that you think people care. I would have gone somewhere fun last week and just been like, nobody cares.
I think people are deeply interested in the things that I have to share.
I never get to go anywhere fun.
And if you did, nobody would care.
Nobody would care.
Nobody would care.
I'm not sure I would even care.
Why would you care?
Hey, how come it won't let me chat with it won't let me chat on the YouTube's thing anymore?
Yeah, and Ray, we only got 3 watching. Like, did you put this to your Facebook and say, "Hey, my thousands of Facebook people, we're about to talk with a guy who hasn't showered in a week, and also Matt." No. I'm that guy, if you haven't figured it out. How do you guys like this? This is we're going on like almost 2 weeks of growth there.
Look at you Grizzly Adams looking SOB.
You can almost see hair. You know what I'm saying? Like another couple of weeks, you guys, you'd see hair.
Okay, so back to my latest attempt. Here we go. And there it is, ladies and gentlemen. Just like that.
This is your place, Ray?
It is.
Wow. You have a tree
in front of the ranch. I do. There's also this is a big pavilion right here. It's like a 40 by 60 foot pavilion.
Is that for like pulling your RV under?
Oh yeah, that's exactly what it's for.
Yeah.
Here's a top. This is Melissa walking. This is another shot of the pavilion. And then you can see neighbors. That's a dentist right there. That's the local dentist. That's the sunset. This is sunrise, and that's me walking my dog. See, just like that. You feel like
it. No, you can play baseball. No soccer allowed. I don't even know what town that is, Ray. That's my kind of town.
You're like, Woodstock is the town.
Pat's,
Soccer? No soccer.
Pat's ideal town has no jet skis, no soccer, no fun, basically.
Or you know what? I'm okay if I had a jet ski because I would use it responsibly. But it seems to me that the vast majority of people on the chain and in the coastal waters of the Florida Keys, not as responsible as I would be if I had a jet ski. Now, perhaps I would be irresponsible if I had a jet ski. I don't have one, so it's hard for me to say. But I described them to Matt. Jet skis are like the Chicago Cubs. I don't hate jet skis. I hate their fans. I don't hate the Cubs. I hate their fans. Ray, what do we got going on over there?
Not me.
Those are my dogs. Sorry if you can hear them.
It's Matt.
So Ray, it's a ranch. What are you going to ranch out there?
I'm gonna wrangle.
What could he ranch? Goats is what it looked like to me. I mean, what else grows out there? Nothing.
Alpacas? Llamas?
Camels?
You didn't see, apparently you haven't visited Facebook and you haven't seen the deer and the antelope roaming across the
Can you shoot them and eat them?
I think you could. They're pretty they're not very skittish, to say the least.
Well,
they do not care.
It means that people probably aren't shooting them and eating them.
But Matt, you said that there was a Elephant Rock motorcycle trail, and that trail is in the north of New Mexico, but there is a series of roads that take you from that area all the way down to our backyard.
Wow.
But that's all something that we have to explore. So
Are you gonna start motorcycling and four-wheeling, Ray? You already have four-wheelers, right?
I had four-wheelers. I bought two four-wheelers. I bought the Honda 250, which is kind of a weenie one. And then I bought a smaller Polaris one for my son. He hopped on it, grabbed firmly to the handlebars, gave it full gas, ran about 30 yards wide open, straight into a tree. He broke both of his arms.
So end the tale of four-wheeling in the Flavin house.
I'm not. Where do we get to the weird part of here?
Is it mean to do this?
Where do we get to the part of this that's abnormal? Because this just sounds like a normal four-wheeling thing to me.
Now let me ask you this: I don't four-wheel or motorcycle, but if you were to take four-wheelers on the motorcycle trail, would that be as bad as taking four-wheelers on a snowmobile trail?
So I can tell you that there is a lot of friction, at least in the Midwest, between the motorcycle people, the off-road motorcycle people, and the four-wheel people. And it's based on two things. Number one, the four-wheelers really are not in vogue anymore. People are driving the UTVs, which are as big as Jeeps. So the trail maintenance and the trail size has just exploded in the last 10 years. Two, and I say this as somebody who's ridden off-road motorcycles for 30 years now. The four-wheel drive, those people are butthurt basically because they're required to get special stickers and stuff for trail maintenance. And a lot of times the trails that they're put on are old logging roads. And those of us with street legal motorcycles can just buzz down them because they're old roads. So there's a lot of friction because there's a sticker system. So a lot of times when they're on private property and not on roads, they will explicitly exclude motorcycles. And then there's motorcycle trails up there that have now gone the other way and said, we're not going to let ATVs on them. So you would think these are groups that could get along, but there's actually a good bit of friction, at least around here, between the two groups.
It's a civil war.
I think to tell you how dumb it is, for instance, the snowmobile people in Wisconsin and Minnesota several years ago were lobbying that people who are riding their fat bikes in the middle of winter on groomed snowmobile trails, many of which go across lakes or swamps or public access places, that the cyclists should have to pay for trail access just because they were forcing the snowmobile people to pay for the DNR stickers to maintain the trails. So it's a pretty good lesson in how just even a little bit of permitting causes a lot of really weird dynamics back and forth that otherwise wouldn't be there. But you don't see, at least around here, integrated like snowmobile, four-wheel drive, UTV groups. They're all warring for different factions of land, and they're all at odds, and it's really dumb.
I remember 1,000 years ago when three-wheelers started becoming popular.
Yeah.
I saw a bar fight up in Wisconsin because some dude pulled up, there was 45 sleds and this dude pulled up on a three-wheeler and it did not go well for him at all.
There's actually a state law up there that you're not allowed to take a wheeled vehicle on what is accessible as a snowmobile trail after December 1. And the trails by Ray, to get to the point, are old mining roads, and I think they're in federal land. So an old mining road on federal land should be accessible to any licensed vehicle. And basically what they've done there is they've cleared them just enough for motorcycles, or at least that's the gist of what I read from Ray's thing. So, but no, keep your UTVs away from there.
Fair enough.
So good for you, Ray. Did you close on that place?
Yeah, we did.
Oh, congrats.
Yep.
Thanks.
Congratulations, Ray.
Thank you so much. We were, it took a lot of, there was a lot of things that we had to do over a short period of time. We're looking forward to getting back down there and getting things done. So I just thought that I would share with you that as it turns out, let me see if I can.
Are Ashley Anderson and Elizabeth Kelly your paralegals, Ray?
Ashley Ander, I don't know who those are.
All right. Man, why are you trying to get me fired up, man?
Well, it turns out that this is not on October 29th, the Northern District of Illinois, or the federal circuit, made a decision that they would just suspend all jury trials through January. So in McHenry County, we did that right away.
So
okay.
I was about to connect a bunch of dots for the people, Ray.
Oh, wait, we didn't do it right away.
So here's the dots that need to be connected. Ray files, can we talk about this? Ray files a motion in the middle of October that says, I don't want to do a jury trial because McHenry County is a COVID hotspot. And because I'm Ray, I don't say I don't want to do a trial. I say the relief I'm asking for is to close the entire courthouse because I'm Ray. Because why?
Well,
Ray's not there.
The relief was a concern. It was a concern for the jurors.
Ray, I like the fact that you're not just trying to help yourself, you're trying to help everybody.
I try to help everyone. Why wouldn't I?
So Ray files that. And then I'm like, I don't really feel comfortable doing juries here. It's not like I haven't tried it, but this virus is getting out of control. I start filing motions to continue. This comes down and I kind of send it to the Northwest Herald and say, hey, are you interested in the fact that the federal courts have decided there shouldn't be jurors showing up to court at all, and McHenry County is acting like nothing's going on? To which she says to me, yeah, I'm already writing a story about Ray's motion. So,
but it wasn't just about Ray. I am in the middle of two celebrities right now.
I was going to say, so shortly thereafter, Ray and I appeared in a Northwest Herald article that ran, I think, on a Sunday morning, wherein we were, I don't know, critical is the word.
I hate to use the word critical. We had some suggestions.
You could say it was lightly critical, right, Ray? I mean, you could say
you voiced your concerns.
We voiced our concerns. Ray and I said that we don't think that there should be basically court and trials going on, and I thought it was a pretty balanced piece by Ms. Smith because she had quotes in there from the trial court administrator and the health department, who was dumb enough to say that they're not aware of COVID coming up from the courthouse, as though they've made any efforts to find out. That was my favorite part.
I don't know. It was better than that. First of all, they were unaware. They were unaware of any cases. So then the reporter called the state's attorney's office and said, hey, what about those two people that you didn't report, but was widely reported were exposed to COVID. And the state's attorney had no comment. Then there was a law firm where you're not supposed to, there was a law firm where several members had been exposed to COVID, and there's no system to tell everybody that they've been exposed. Oh, were you guys in front of 104 this morning?
No.
Yes.
There were 60 people in the lobby. 60.
Did you see 301 and 303?
I did. I didn't make. I was up. I was too busy doing 104 and doing 203.
So it's crazy to me, guys. By the way, they announced 2 days ago that Kane County is completely remote through the end of the year. Period. There's judges who will do order of protection hearings and possibly do bench trials. Everything else is remote. Period. They don't want anybody in the courthouse. But the crazy thing to me, the takeaway from that article, forget the health department's just insane comments that they're not aware of that. Forget the trial court administrator's crazy comments that like it would require more staff to do more remote because every other county's figured it out. Forget all that. The takeaway is of the people who were kind of saying, nothing to see here, 0% of them had to walk through the front public access door and wait in lines. 0% of them had to walk through the hallways to see what's going on in the hallways. They're getting a great bird's eye view of what's happening in the courtrooms, and in the courtrooms, it's great because they've done a great job limiting who can get in, but they're doing a terrible job. Like my exact quote, I think my quote was great. I walk out of the hallway and I walk through a cloud of COVID, and that's exactly how that place feels. And I mean, you guys know I basically have a part-time job being critical in McHenry County, but I have been, I think, in 6 other counties since this happened. And there is not another county that has those people. Kane County has done the math on how many people it can have in the entire hallway upstairs. They won't even call more than 25 people into court for the day if it's going to be more than 25 people in the hallway, period. And you've got courtrooms that by themselves have 25 people waiting outside in McHenry County.
My firm has 57 cases in 301 and 303 tomorrow. Just those 2 courtrooms. Well, okay, but just so we know, the 22nd Judicial Circuit continues to operate during coronavirus pandemic with safety measures in place for the protection of all people who enter the Michael J. Sullivan Judicial Center. I don't know what those are. I'm there every day.
I would think that they
with an 11-day break.
They only allow 2 people to ride on the elevator at the same time.
So the fact that there are people literally assholes to elbows, pardon my expression, in the hallway.
Well, and then the problem with the hallway is, I mean, just so people who are watching this understand, in the courtroom, they only allow a number of people that fits the number of people who can safely distance, even though that gets blown over all the time. But the problem is that leaves everyone else, the 57 people that Pat was talking about earlier. Where are those people at, Pat?
They are stacked up in the hallway waiting. They're in the lobby, in the anteroom to the courtroom. They are conference rooms. They are everywhere.
All right, now you guys are going to make me show you something that I didn't want to bring up because I had gone over it a couple weeks ago, and then I buried it because it hurts. But you, Pat, you, I know back in the day you used to work in Sycamore, or not exactly like, sort of a bastion of liberal idealism, the kind of place you think if it's going to deny COVID, they would. So one of the things Sycamore did is they took, you probably haven't been there since they put the addition on the back. They had a big area and it had like benches. Well, they removed the benches and they put 15 or 20 little desks in. Then on the side of the desk, they put like privacy, like kind of a privacy colored plastic. And then they put a partition through it. So you can actually sit there face to face with a client with your face mask on, but be this far from them through a thing, and you can pass stuff back and forth. And I thought that was kind of a nice way to basically try to make it, like we can't exist without talking to people in the court or in the hallways, whether or not they want us to. When I looked, This is something that was adapted straight out of the Supreme Court papers that came out in March. I looked this stuff over and I could not believe some of what I saw. And I'm going to show you guys this document. And this is the part that drives me nuts right here. If you look under messaging, this is the Illinois Supreme Court telling circuit courts how to handle somebody in your courthouse who got COVID. If the public learned, first of all, if you go farther up, it talks about isolate, remove the symptomatic individual, and then collect information, like find out where was this person, what courtrooms were they in, who else can we tell. That all involves contact tracing that is point blank not happening in Woodstock, period. Because if it was happening, we all would have been notified based on the rumors of who has COVID. And I don't know about you guys, nobody's come to me and said, hey, this bailiff, this state's attorney, these people, this client, whatever, got COVID. But where I think McHenry County is just failing colossally is read what it says about messaging. It says that if somebody in the courthouse has it, it's very important that you as a judicial system tell people that they were exposed, because if people find out they were exposed to COVID in your courthouse and you don't tell them, it looks really, really crappy. Really crappy.
Oh, Matt, but we have those systems.
I'm sorry, am I missing the press releases that are telling me that I was with
They
the
just don't tell you, Matt.
Well, you say that tongue in cheek, Ray. However, we have had a couple of clients who were positive. The county, the Department of Health did find out about it. We had one of our associates who was extremely pregnant at the time in court with this individual. The county Department of Health called the courthouse. The court administrator, he of the previously screen shared press release, called our client's civil lawyer, who hadn't seen him in 45 days. That was the last time they were in court together. Called his civil lawyer and said, hey, one of your clients has tested positive for COVID. So certainly they would tell the pregnant attorney who was in court with him that day that your client tested positive for COVID, right?
Why do you think they did one and not the other?
I have no idea. But luckily, the civil lawyer
got on the phone
with us, because she is fairly close with one of the people in my office, and said, hey, one of our clients in common, I was just notified, tested positive. Fast forward a couple of months later, where somebody else in our office was doing the 17th day of a permanency hearing, and court administration called everybody but our office on that to say, hey, potentially one of the parties involved in that case works in an office where they've been exposed to COVID. Luckily,
so they're calling everybody else.
Yes.
This says that they should be telling the public. It's like it shouldn't be
that's a bit out of line to say John Smith has to publicly announce it.
No, but if you look, they're saying be very general. They're saying on this day in this courtroom, people who were there were exposed to COVID or could have been exposed to COVID, which I think is a good way to handle it. I want to take us back to some of our very fiery discussions from March and April. Do you remember when the state's attorney's office was arguing and fighting that people who are positive for COVID, that their name and their identity should be turned over to the cops?
Yes.
This is a public position that this office took. And, we're walking into a courthouse in a county that has a 20% positivity rate. And
I think it's a bit higher than that.
Yeah.
There you go again, giving the county the benefit of the doubt.
But my point is, we started this pandemic with them saying this is such an important public health issue that cops need to know. And now we're on to, hey, those of you who are potentially having daily exposure, we're not going to contact trace. We're not going to tell you. And we're publicly going to say, well, we're not aware of it having been in the courthouse.
Now, I do know somebody who got a call from a 312 number. This person had tested positive. The number comes up, COVID hotline, COVID something. It's a 312 number. Hi, this is Susie Smith from the McHenry County Department of Public Health. Not from a 312 number, it's not. They ask, is this so-and-so? And the person says yes. And they said, okay, we're going to need you to confirm some personal information. We're going to need your date of birth. We're going to need your primary care physician. We're going to need your address, your work phone number, and your cell number on a cold call.
They didn't ask for a credit card?
Well, not yet. They had to make sure they were getting the right one. To which this person said, no, you're not the McHenry Department of Public Health. You're calling from a 312. And why don't you tell me the personal information that you have? The response was, oh, we can't just give that out to anybody. We don't know who we're talking to. That was the attempt at contact. So needless to say, this person said, thank you. I appreciate your concern.
Yeah.
But that was the attempt at contact tracing.
I've seen.
Well, I don't know. It sounds like it was a scam from somebody who's getting information from, whatever. But I mean, really, that's how you're going to go about it. Give me something to where I could at least start a credit card in your name, and then tell me about your COVID.
I just know. So earlier today, our Kane County Defense Club had another Zoom meeting, and it started with the sheriff coming on, and then the second guest was the elected state's attorney, right? And the sheriff is talking about how Kane County is trying to push a lot of people who would be doing county jail sentences onto electronic home monitoring right now. And there were a lot of questions about how do you pre-screen? How do they know? Because the decision isn't made in court, it's made by the sheriff. So we had, I don't want to say we got a ton of information, but at least that guy came on and he talked to us and said, this is how we're operating during COVID. Then the state's attorney came on and she was like, I come in December 1 and here are issues that I know came up the first time there was a COVID lockdown. Let's talk about resolving this. Let's talk about moving discovery. Let's talk about continuing to move cases. Let's talk about continuing to work. It's like unfathomable that McHenry County would accept any kind of transparency or even dialogue on that. And it goes back to what we've said a million times, like nobody ever asked for our opinion. Well, Ray and I got quoted in an article where a lot of people who don't walk through the front door, who don't go in the hallway, and who don't see people every day have a lot of opinions. And their opinion is they don't need to talk to Ray or Pat or Matt because they already know what's going on. And reality is they're walking through a back secure door, they're going into their secure offices, and they're sitting there all day, and they don't have any idea what's going on in that building.
No, they I mean, and no.
So
it goes back to the criminal reform and everything else that nobody wants to know. They want to have people they perceive to be players in it, people who haven't had any active participation in the ground level court system like we do. You're going to have somebody. It's lip service. It's lip service to make themselves look good.
What bothers me about this is, you taking COVID home to a young kid or an older adult. I mean, we can talk about the death rate. Nobody knows what COVID's long-term effects are on people's lungs, brains, or heart. Like it hasn't been studied and nobody knows. And to me, there's a huge lack of empathy for what our families might be going through or the families of these people. And then you get in situations where judges are questioning a guy. Like I had a client who says, I'm super scared of COVID. I've got a bunch of other conditions. Can I stand in the parking lot and wave to the window? And the judge says, well, if he doesn't come in, he gets a warrant. Or like Ray's client that was talked about in the article, and the lady gets a warrant. And it's like, there's just a huge lack of understanding and empathy, just what people are going through right now with this dumb thing. And it's kind of ridiculous, to be honest. It's, Dan Wallace can talk about access to justice as an excuse to not do Zoom. And that's the biggest crock of crap I've heard, because the defendants aren't the one clamoring to set stuff for jury trial right now. Nobody has come to me and said, geez, I really want to do some hinky ass trial in a basically a glorified lunchroom right? Access to justice is not an issue at this point. So like, let's start treating people like people, and let's realize that somebody at that courthouse might take COVID home to somebody who can die or get injured. And let's not be those people. I mean, there's a really to mitigate this.
I did get asked today about how we can cut down the numbers. I had 3 or 4 suggestions. All of which were immediately, no, we can't do that. Can't do that.
What were your suggestions?
One of them was, okay, on initial court appearances in 104, let us waive their appearance until we need to set it for trial. They discussed the potential of doing Zoom in 104. That's not feasible.
Why not?
That's not.
Why? Why?
Oh no. Oh
why?
God, no. Oh God, no. We've been doing Zoom in Lake County. It's an absolute cluster with any kind of volume. To do 3 cases on in a courtroom out there is easily an hour.
Are you kidding me? Because in Kane County, it was a nightmare when they started. There was a lot of like, hey, the judge is on. Do you hear me? I can't hear you. Okay, I got to go off. Sir, restart. Some of those judges now are so good at Zoom. They are whipping through stuff and unmuting you and addressing you. And it's really, I mean, some of those judges are so good at it that I don't see how it's slowing things down. And I like that. I was 2 weeks ago in one of the high volume branch courtrooms there was literally one person in there because they've got it down so good.
Well, Lake County's volume is too high, or I don't know.
Well, the other thing is like you can't run it like you can't just take Zoom and apply Zoom the way you normally run a courtroom. You've got to run it a little bit differently.
Well, and my thought was, okay, well then let's start doing Zoom. Let's say, okay, my time slot is from 8 to 8:15, and I'll crank out all my things at 8:15, and then I can get upstairs and I can get up to the courtrooms in Zoom at 8:15. My suggestion was let us waive their appearance until we have to set it for trial. So that way only the things that are going to go upstairs to be set for trial will be there. But we can't do that. We have to arraign them. You can arraign somebody and enter a plea of not guilty.
I hate to tell you
almost simultaneously.
There's a no. If you enter a plea of guilty, you don't need an arraignment period. And there's
no. I said enter a plea of not guilty if we're going to move it upstairs.
Yeah, but you don't need to do that. You don't need to do that. There's a felony judge in Kane right now who just stopped doing arraignments. If you set it for trial, he arraigns you then. If you plea, you never get arraigned. You don't need to be arraigned. But like that's all ridiculous nonsense because somebody has figured out a way to do it. But look, let's be real here, okay? June 1, Pat, you and I both said we're ready to go on trials. That client of mine, that was the second time I answered ready on her trial. The first time was in, I think, January or February. And on that day, we were a 1-year-old case and we were number 13 on the trial list, right? So at a year in, we were 13th on the trial list. We answered ready and we got booted. Then we got booted to June and we had the COVID issues. But the reality is you cannot get a jury trial in McHenry County unless your case is 18 months old because the stuff in front of you is going to go. So why don't we recognize the pace at which cases work? And Pat, we don't have to just waive people's presence till it's time for trial, but then fine, waive their presence on the first court date and give them 90 or 120 days or do Zoom a couple times in there. It's ridiculous to force people to keep coming to court during a pandemic when they can't even get a trial if they want to, and they can't speed up the process by virtue of a speedy trial demand. The reality is all you're doing at that point is you're trying to grind them down and force them to plead guilty and say, hey, you can plead guilty and stop coming to court. If you want a trial, I'm going to keep making you come every 4 weeks. It doesn't make any sense.
There is one of the misdemeanor judges. One of them is going to allow Zoom for clients. The other one told me, I don't want anybody here on a pretrial conference date until I tell you otherwise. So, I mean, to that extent, they're making concessions. And that's the three of us have always said that that's the whole purpose of that pretrial conference. You're going to take off a Thursday or a Friday and a Monday, so you're essentially going to be whacking 5 days there between Friday, Saturday, Sunday, Monday, Tuesday for a jury trial. your life's on hold for 5 days. And that has done wonders for their guilty plea percentages. But what I don't think you're taking into consideration when you're saying all that, either one of you, is pie charts. There's pie charts.
We have
pie charts, man.
I almost made a comment about the pie charts. I'm so amused that a group of people who are politically powerful and also politically insulated give a rat's behind about the pie charts. Because if I was a circuit judge and somebody sent me a pie chart of my cases, I would respond to that in a way that would allow them to know that they didn't ever have to send me another pie chart.
If you're an elected official, you're gonna take grief from a guy who's never practiced, a guy who's never been elected by the populace of your county,
who is a lawyer who's never done what we done, trying to tell you how you should move stuff.
But I think that what happens is that I think that the pie chart people talk to the chief judge, and the chief judge talks to the circuit and says, hey, you need to play ball.
Clearly.
Well,
Clearly.
no, well, hold on a moment. These people all have to coordinate their vacations. Okay. Like, Matt, you're taking Thanksgiving. Pat, you're taking Christmas, and I'm taking New Year's or whatever. Okay?
5 weeks apiece, Ray. That's all I get.
Only supposed to survive that.
You're supposed to say only 5 weeks. Only 5 weeks, Matt.
Restricted to 5 weeks, Ray.
But the idea is that you have to have a certain coordination in the larger scope of things. And part of that cooperation is getting your pie chart done. Because they try to move stuff. There's something else they do. They try to move stuff off days that they're not going to be there. So when somebody gets a double call, that they don't get a double 70-page call. They get a double call, their call plus 7 pages of another thing. You know what I'm saying? They move cases off so that they won't swamp somebody.
It's crazy to me, and this has always been the model, and this has always been such backwards thinking that is obvious to you guys, but, and this isn't just McHenry County, nobody thinks of, the people who make these rules. And that is, I can think of 100 ways to alleviate congestion in court that don't involve pressuring judges into moving cases at an unnatural pace.
Well,
there's a million other ways.
If it's not us and it's not judges, who else is there, Matt?
No, hold on a moment. I think that you might be missing something, and I didn't want to miss the chance to get in trouble here. If they were effective at moving the cases, there would be a smaller workload. If there was a smaller workload, then we wouldn't have 17 judges in the county.
No, there wouldn't be a smaller workload. You would just cycle through the same number of cases at a much more rapid pace.
But once you ran them out, they'd be gone.
No, but Ray, the cops don't stop arresting people. I mean, I
understand the cops don't arrest people, but if it takes me, and this is I'm giving bad numbers just to make my point. If it takes me 12 dates to do it normally, and I can do it in 5, then that means that's 7 less court dates, so that there's less work to do. If there's less work to do, then maybe we need fewer judges.
No, I don't think
the way they fight me on continuances, I don't know that that's necessarily systematic.
I don't know that you're eliminating the number of people, Ray, because that's controlled by the people coming in. What I'm saying is, if on your 3rd court date, you're getting the offer that you're getting now as a result of a pretrial where a judge is twisting the arm of a prosecutor, coming on the 3rd court date. I mean, how many of your cases do you leave that's pled out the day before or on the day of trial or the pretrial where you say, you think to yourself, if they had made that offer when I asked for it a year ago, we wouldn't have just wasted 12 court dates. And that to me, that's a huge part of it, is just
to me that happens way more in felony than it happens in misdemeanor.
Oh, absolutely.
In misdemeanor, I kind of know which way it's going to go, but in felony, you'll get the weird minimum DOC offer, which you're like, yeah, I can do this all by myself by losing the trial and doing a fairly good sentencing hearing. Yeah, so I don't care. But then you get next to the felony date and they go, oh yeah, oh, we can reduce it to a misdemeanor. We always could. And you're like, you always could.
I have a client who had a class 2 strangulation that we like victim issues. The victim's a little kooky. She's probably not going to show up, whatever. Maybe she's going to show up. Maybe she's going to not. And I asked 3, 4, 6 months ago, I sent an email saying, can offer this guy a misdemeanor and let's just be done with it. And I get a response that's like, I'm willing to offer him conditional discharge on a misdemeanor and 180 days in jail. And I think to myself, like, we go to trial and lose this and I'm not sure we're getting 180. Why would I jump on this? This isn't that great. So I don't say anything. I'm not going to waste my breath. I know what the response is going to be. On the pretrial date in 302, judge is like, what's going on? And I say, Judge, we can get this done for a misdemeanor. And the prosecutor explodes and says, I offered you a misdemeanor. And I say, yeah, with 180 days in jail and a high fine. And the judge just looks at the prosecutor and says, look, state, that's a little ridiculous. Get rid of the jail, cut the fine to 200 and be done with it. And he looks at me and I'm like, that's done. That's done. If I didn't have to go through that process, if somebody was recognizing, instead of making offers that made me look tough, if people made offers that were paralleling what we know the judge is going to give, especially in felony court, your pie charts are not an issue at that point. That's just one of the many ways that the pie charts can be alleviated. And the reality is that the pie charts mostly put pressure on us, but who's getting squeezed in a lot of these pretrials? Sometimes it's us, but a lot of times it's not.
I mean, I guess my question is, you're selecting these people to the bench because you trust them. You think that they're going to be good jurists. You obviously thought that they were good practitioners. Let them do what they want.
Exactly.
Let them do what they want. And if you don't trust them, then maybe they shouldn't be there. Find somebody you do trust.
You're taking a position where they have zero control over their own caseload. Their caseload is set by the state attorney's office and the police. And now you're telling them that they have to move cases at an unnatural pace because you've read some study that says.
And if you're moving a case to move a case, are you really giving people equal access to justice, or are you just disposing of their case in a fashion that makes you feel as though you're accomplishing some pie in the sky nonsensical task because you felt that pie in the sky nonsensical task needed to be accomplished?
Sure.
That's like me going to the Chicago Fire and telling them how to play soccer. Yeah, I'm gonna go tell you something that I've never done. I have no idea how to do it, and I have no idea how to run a soccer team. But here's what I'm going to tell you how to do. We need to only score 2 goals a game.
Yeah,
let's do that.
And does your
you would win most of the games if you did that, Pat.
Yeah. I've got a stat that says that games that are over in 44 minutes or less, people win. So let's make all games 44 minutes. That's the thing, because the other thing that it fails to recognize, and this goes to your point, Pat, is, on a major felony where there's medical records, you're going to drip that stuff to me over 9 or 10 or 12 months. I'm going to get videos 10 months later. And now a judge is going to scream at me 60 days later when I have 16 videos dropped on me that I got to set this thing for trial. How is that fair to my client? How's that access to justice for my client?
I like it better. I like it better to get my videos on the eve of trial. Thank you.
Yeah. My favorite is to get that stuff like 2 days before trial and be like, whatever, still ready.
It didn't exist. It didn't exist until the week before trial.
But if you want to be fair about this ridiculous pie chart thing, then your pie chart time should start at the minute I get the end of discovery. And if you hit me with discovery after that, set that thing back to 0.
No, if you hit me with discovery after that, that discovery doesn't come in.
Well, Ray, why don't
we have grown-up rules? Why don't we have grown-up rules for court?
Ray, if the state can't use discovery, how will they win? Come on, Ray.
Ray, are you suggesting that the state, with their no resources and their overworked and overburdened police departments, are you
no way to operate that office with any less than $3 million a year?
Are you suggesting that those poor people be held,
not including salaries?
What is their budget?
Get us stuff timely.
It's $1.5 million, but that doesn't include the salaries. The salaries are paid by the county, so it's But you have to remember, they have quite a few secretaries. They have a big staff. And the other thing is that whenever you look at a budget like that, you never can compare that budget to, like, for example, a big law firm like the one you're from, Pat. I mean, you guys have to pay your rent. You have to pay your staff. You have to pay every moving part that happens there, you have to pay for. That's not the way it is on the government side.
No, I pay for that too. I pay for videos. I pay for copies.
Oh, Pat, you're paying for your subpoenas and their subpoenas, right?
Oh, yeah.
Trial comes.
Yeah.
Their space is free, and I think their health care is covered by somebody else. So when they say our budget is $1.5 million, they're not talking about everything. They're talking about the part they have to pay for,
which is becoming less and less.
Oh yeah, of course.
I love paying especially for some of these municipal guys. Well, it takes time to copy reports and to put everything on a disc and bump. So, I offer to supply, a tower of discs.
How many CDs will I give you? I'll give you all of them.
Yeah, I'll give you a year's worth. Stop charging me.
I'm going to drop you off a box for the entire defense bar because they're like a penny a CD at this point.
Well, the other thing is that, I mean, we're right at the brink where this lie is going to fall over. Why are they copying things? They should all be on PDF. You should just email them to me. Cost to you would be whatever your staff time is, but you're not supposed to charge us for that. So the cost should be zero.
Well, now we're paying $35, and I have to pay to print it out.
Oh, yeah.
If I want a hard copy, or I'm paying for Dropbox or whatever, but we're still paying for them to go click, or sometimes they put it on a thumb drive.
Well, what's been happening recently is with evidence.
Those are convenient to keep in a file.
With evidence.com, they send it to you for free.
Oh, is that a third party? Is that the third party that has access to discovery that I can't give to a third party?
That is the third party that gets evidence because of that Supreme Court rule that allows them to get it. Do you know what Supreme Court rule that is?
The Ray and Matt rule? Oh, no, not the Ray and Matt rule.
That's not a Supreme Court rule.
415.
There is no such Supreme Court rule.
Yeah, I mean, you guys have heard my beef with evidence.com, right?
Yes.
You know who owns them?
The people who own Taser.
Yeah. And
I listen, Pat. I listen when Matt talks.
Originally, yeah. Go ahead.
And it does expire too, right? Like if you don't pick it up.
No. Evidence.com expires a long time away, like 6 months.
Oh, okay.
When they send you stuff on Justice Web, I think you got a month, and then it's off. You can't get it anymore. And then
evidence.com originally was making their money by charging defense attorneys access to this, or basically embedding the player where you could look on and you could play it one time to view it. And then if you wanted to play it again, either it was unavailable or you had to pay. That was the original data sharing model that Taser went with that. And that still, I think, is in effect in other states. I mean,
that seems totally constitutional. I
Taser has positioned itself as a data storage company right now. That's why they've got the camera. I don't know if you've seen the cameras that are in the Tasers that you really can't see anything except it moving around on. But that's what they've done, and they are the industry leader.
Pat and Matt, I do have a question for you, and I'm not playing dumb. I am as dumb as I seem. But the thing is that Supreme Court Rule 415 says that I cannot give videos or police reports or all of those things to my client, except for now in certain parameters. But before, it used to say the only thing I could do was review it with a client. Okay. The question I have for both of you, and I'm talking about the old Rule 415, not the new one. On the old one, how is it possible that the accused doesn't get the discovery? And the discovery, for those of you out here, or the three of you that are watching, the discovery is what happened, what other people are going to describe what happened. How could that not be given to the defense?
Well, what I love is if if they represent themselves pro se, they get it all.
Well, I know. So why do if they have an attorney? Does it change that?
Do you guys?
I never understood that.
Two things about this.
I understand it. You know why I understand it? Because the Supreme Court that writes the rules never practiced law. Sorry.
Not on our side.
Sorry, not sorry.
So I want to tell you guys one, and maybe we can discuss the other off. Do you guys know what happened to change the rule during the pandemic?
I do.
What?
Don Ramsell.
Yeah. Did we have this conversation?
I don't know that we had it. I read it. I read something where he was on the committee where he was like, yeah.
So Don Ramsell, as soon as the pandemic hit, and I think I know some things a little bit about his practice. I don't know Don, but I've talked to him a couple times about other things. He was pretty vocal on every defense lawyer or criminal justice email list he could be about it, and he's the one that kind of has pushed this through. But what I think is a joke about 415 that people kind of aren't picking up on is the way 415 is set up, where you file a motion and if they don't object, it just kind of happens. But then you have to redact all personal information. All they did in 415 was codify the current FOIA rule. All that stuff your client could have gotten 5 days through FOIA anyways. So it's kind of a joke for the court to come back and do this. I mean, I don't want to give my client a bunch of redacted stuff.
Well, you know what? What is the better practice? And I mean, just talking about going forward now that they've enacted this rule, a client hires you, have your secretary fire off a FOIA request that goes to the defendant, and you just do that as part of you being his lawyer.
I've already done that
all this stuff.
That was my normal practice. When people asked me to see the reports, I'd FOIA them and I'd say I can get them to you through FOIA. So I've done that before with videos. I've done that with reports. I've done that with all kinds of stuff. Some of these police departments, though, are just, I don't know who's giving them advice on FOIA, but they're redacting, for example, the entire narrative of a case. Yes. So they're doing stuff that they shouldn't be doing. I mean, FOIA is about transparency, and a lot of these FOIA officers are it's kind of like presidents who are staffing the Environmental Protection Agency with people who don't believe in protecting the environment. There's a lot of that going on in the FOIA that maybe this helps us avoid. But, Ray, I've done that in the past, and that's probably what I'll continue to do, because then I'm not in trouble if I forget to redact something. Their FOIA officer is.
Yeah. Well, I don't know. It's always driven me nuts. It's asinine.
It's like you guys said, it's a rule that is made by people who've never tried to defend a person and get their version of what a cop says without being able to let them take, a video home for a day. Or, I've got a case I did a trial on, I've got to do a retrial on. There's 6 hours of interrogation. Yep. It's not feasible that this guy can sit in my office for 6 hours and I can sit there and we can have a conversation. I should be able to give that to him. He should go home. He should watch it. He could come back with his notes. But the reality is that at the bottom of it, the reason they're comfortable doing that is because they just don't give a damn. I mean, they feel like, here's a little bit of due process as a treat, basically. You don't deserve any more. So.
Who had the end of October, beginning of November for the second monstrous surge?
I think I said August, so I think it was off on that.
I was late summer, but Ray, did you call October?
I'd have to go look at the.
I thought somebody had October.
I know that all of us. I know that 3 out of 3, we weren't predicting weather. Nobody predicted weather.
No.
All of us predicted. When there was no line on whatever. So what do you, as far as the court finally succumbing to COVID-19 before the vaccination or the vaccine kicks in, when do you think we just close like we did in June?
Which court, Ray? Because Kane County has already done it. The federal courts have already done it. What's that?
No. I don't. We're always talking about McHenry County courts because all the other courts, closed a while ago.
I think McHenry County is going to run right through this COVID storm with their head up like a freaking peacock, beating their chests about how we're just continuing to freaking operate and we have access to justice. I think those idiots are going to do that until
I'm going to renew my other prediction. And
hold
this
on a second, Ray. Because I want to stick you in the Wayback Machine, and I want to. If you go back to March, if you recall, the conversation was, "Ooh, Kane closed today. Ooh, DePage closed today." And then McHenry County was forced to close on like a Thursday or Friday night by Supreme Court order. They didn't close willingly. They were told at the end of the day, you're not opening tomorrow. So I think unless the Supreme Court steps up again, and we can talk a little bit about how the Supreme Court has been terrible kind of guiding the courts through this, but unless the Supreme Court steps up again, I anticipate you're going to get the same attitude out of them as you got before, which was like, this is what we do, stop us.
I think the concessions that we see right now, the jury trials, which will probably go till the end of February. I think we won't have any juries till the end of February. I think the concessions that you see now allowing people in certain courtrooms to do Zoom, and they may all be Zoom by shortly, but I don't think anything will happen beyond allowing Zoom appearances.
My prediction is the same prediction that I had before, and it's this. If one of two things happens, the court will close within the week. We have an attorney die or we have a judge die. And as I said, we continually spin the wheel. So at some point, that will be the result, and then they will close. And then they will talk about how nobody could have predicted it.
Sure.
And how nobody could have, it was impossible
like
to predict.
A county board
And we
member
were doing
died of it.
We did everything that we could possibly do in order to protect the public. That's what the spiel is going to be. And then they're going to be, but apparently we weren't able to protect it enough. And then they're going to close. Trials will turn back on in May. May is when the trials will turn back on.
Except 3 knucklehead Nostradamuses who've been doing this since March. Only they could have foreseen.
Only.
Rubbing the crystal ball. What do you see? Tell me.
I just like, to me, I mean, if you want to go back to probably like April when we were talking about this, I talked about Pascal's wager, which is something a lot of people who are not fully able to kind of articulate why they have a certain faith or religious faith can and do use to talk about why they do have religious faith. And the idea is basically like, it's better to kind of err on the side of belief. I don't understand what is going on in McHenry County that they think that they should just disregard the risk right now. I mean, a county board member died of COVID last week, right? What do they need to see to believe that this is killing people? And we can talk about what the death rates are, but the reality is that there's people showing up to that courthouse who've got family who got killed from this, who don't want to take it home to their kids. And I don't understand what is the great harm to the county or the judicial system by retooling what you're doing temporarily for 2 or 6 months to kind of get through this. I don't understand what it is. And I would hope that in the end, people recognize the gross lack of empathy right now. I'm not saying things have to be ground to a halt, but man, I would love to walk through a hallway that's not filled with people who are just showing up to get another court date. It's ridiculous.
There was a guy in 104 today just hacking up lung butter. It was brutal. And finally, I mean, the bailiff is just like, "What's your name? Let's go," and got him out of there. But I don't know if this dude had COVID.
That guy would have been at other counties. He would have been asked if he had a fever or had been coughing. I mean, they would have said, "Do any of these apply to you? If they do, please don't come in. We're going to call up the court right now." And it's not happening at Woodstock.
I told you every college visit we went on with Tommy, man, it was like something you'd see in a 1980s sci-fi movie. Stand here, scans you, any coughing, fever, boom, boom, boom on a tablet, check. The guy would come over, wipe off the tablet. The next guy would come in there.
There's
They'd
no
scan it for-
way, there's no way to contact trace those people, Pat. Except for I went to a restaurant the other day and they had me sign a sheet because of contract tracing. And maybe they have maybe the IT people who would work at the courthouse are working for that restaurant.
Ray, I read
That explains it.
in a Northwest Herald article that like it just takes too much staff to do that. Look, first of all, I can't let this conversation go without pointing out that I have never seen a front door as robustly staffed as in Woodstock. I mean, if you go there at 8:00, they have 9 basically sworn deputies running 2 metal detectors. So that crowd to start doesn't go anywhere. But King County, for example, has increased staffing by 2 people. And you know what those people do?
Take the temperature.
No. They have the guards do that. They have the ones checking attorney. They have basically a thing you just stop for 2 seconds. It reads you and they say go. And it's the people who have they have an attorney access line where you flash your card, you stand there, it reads you and you go. The 2 staff they have added are when you put your stuff in one of those dumb trays, you roll it through the metal detector. There's a kid with a yellow vest on the backside who, when you take your stuff out, immediately picks up that bin and he sanitizes it and then he puts it in the sanitized pile. Those are the 2 people they added. It has nothing to do with contact tracing. It has nothing to do with any of this other stuff. It does have to do with cleaning, which is something that Woodstock should be doing per that document I popped up earlier. And I'm not even sure they are.
Ladies, you're not going to get paid for any additional time here. Unlike the way that you guys frivolously bill by the hour for everything that you do, I know you do. You're not going to get paid here. We're going to end up cutting it off. For our 2 viewers,
We had 6 at one point tonight.
I'd like to thank the other 3 viewers for participating in the comments, which they didn't. Pat, did you work out that ability to post a comment in the YouTube?
No, I have to figure out what my account and login and all that stuff was.
Okay. Good night, everybody.
Do that right after he gets a background.
Hopefully we will see you soon.
Adios.